Hi, my name is Chaturvedi and I'm a legal intern at LEXIS and Company. So today we are going to talk about enforcement of foreign arbitral awards, international convention and legal regime in India. With the expansion of international trade in recent years, the business world has been increasingly reluctant to litigate in courts of law for differences arising from the international commercial transaction ability to communicate with and commute distant places with the utmost speed enables a merchant in a few minutes or hours to conclude a contract abroad, which a generation ago would have been taken weeks or months. However, when it becomes necessary to resort to the machinery of justice to settle a dispute connected with the contract to enforce a judgment in another country is still complicated, time consuming, and expensive operation. It is not surprising, therefore, that business has been turning with increasing frequency to arbitration as a quicker and simpler means of settling international commercial disputes. There has been a noticeable movement in favor of arbitration. Arbitration facilitates and institutions having increased over time. The favorable trend towards arbitration has been reflected in legislative enactments, international treaties, and other measures by which arbitration has gradually acquired a more solid legal standing. India forms a vital cog of the wheel of the global economy. The ever increasing level of globalization has led to raise international business disputes too. In the context, the enforcement of foreign judgment and foreign arbitral awards becomes significant. A foreign judgment may be enforced in India either by proceeding in execution or by suit upon it. An arbitral award is a determination on the merits by an arbitration tribunal in arbitration and is analogous to a judgment in a court of law. Arbitration is particularly popular as a means of dispute resolution in the commercial sphere. One of the reasons for doing so is that in international trade, it is often easier to enforce an arbitration award in a foreign country. That is, it is to enforce the judgment of the court. The enforcement of foreign arbitration awards in India is governed by the Arbitration and Conciliation Act. Through New York Convention and Geneva Convention, and a non-conventional award will be enforced in India under the common law, grounds of justice, equity, and good conscience. The old law, prior to January 1996, the law enforcement of arbitration awards in India was spread between their enactments. Enforcement of domestic awards was dealt with under Arbitration Act 1940. Enforcement of foreign awards was divided between two statutes of 1937 Act to give effect of the Geneva Convention awards and a 1961 Act to give effect to the New York Convention awards. What is Geneva Convention? On the international level, there are numerous bilateral treaties, including provisions for the enforcement of arbitral awards. As to multilateral treaties, the most significant development since the First World War have been the Geneva Protocol on Arbitration Clause of 1923, the Geneva Convention on the Execution of Foreign Arbitral Awards of 1927, and United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958. The application of both treaties is limited to persons who are subject to the jurisdiction of different contracting statutes. Under the protocol, an arbitration agreement relating to existing or future difference is recognized as valid, that is, irrevocable. The agreement may relate to many matters capable of settlement by arbitration by the contracting states may limit their obligations to commercial contracts. If a suit is brought Despite the arbitration agreement, courts are required to refer the parties to the arbitrators, except where the agreement or the arbitration cannot proceed or has become inoperative. Thank you.